To understand why consent management and tools like consent mode exist, we need to know the legal backdrop. Three major regulations have shaped the requirements around user consent online: the EU's GDPR, the EU's ePrivacy Directive, and California's CCPA/CPRA. Let's briefly overview each. GDPR, General Data Protection Regulation. This is the European Union's comprehensive data protection law that came into effect in 2018. GDPR governs how personal data can be processed, giving individuals rights over their data, like the right to access, delete, or correct it. One key aspect of GDPR is the concept of lawful basis for processing data. Consent is one such lawful basis, and for a lot of online tracking and advertising, explicit user consent is required, especially for anything that isn't strictly necessary for the service. GDPR also introduced hefty fines for non-compliance, up to 20 million or 4% of global annual turnover, whichever is higher. Under GDPR, consent must be freely given, specific, informed, and revocable. So those accept cookies banners you see, that's largely because of GDPR's influence. Although GDPR itself doesn't mention cookies explicitly, that's where the next law comes in. ePrivacy Directive, Cookie Law. The ePrivacy Directive is an EU law from way back in 2002, amended in 2009, that specifically addresses electronic communications privacy, including the use of cookies and similar technologies on websites. It's often called the EU Cookie Law. Unlike GDPR, which is a regulation directly applicable, this is a directive, meaning each EU country implemented it via its own laws, which is why cookie rules can vary a bit by country. The core idea, storing or accessing information on a user's device like placing cookies, generally requires prior consent, unless it's strictly necessary for a service requested by the user. This is why practically all non-essential cookies, like analytics, personalization, advertising cookies, need an opt-in in Europe. Data protection authorities like France's CNIL, UK's ICO, etc., enforce these rules. For example, France's CNIL has fined companies like Google and Facebook tens of millions of euros for making it hard to refuse cookies. The ePrivacy Directive complements GDPR. Think of GDPR as focusing on personal data overall, while ePrivacy zeroes in on online tracking and communications. Notably, ePrivacy is why, even if you might argue we have legitimate interest to do analytics under GDPR, you still need consent to set analytics cookies because of ePrivacy. A side note, there's talk of an ePrivacy regulation to replace the directive and update the rules, but as of 2025, it's not yet finalized, so we still work with the directive's principles. CCPA, CPRA, California Consumer Privacy Act / California Privacy Rights Act. Jumping across the Atlantic, California's laws, CCPA was effective 2020, CPRA updated it in 2023, are a leading example of U.S. state privacy regulations. CCPA gives California residents rights, like knowing what personal info is collected, opting out of the sale of personal info, and deleting data. While CCPA doesn't explicitly require a cookie opt-in banner like GDPR ePrivacy, it effectively means if you're sharing data with third parties for advertising, which can count as a sale under CCPA's broad definitions, you must provide a "do not sell my personal information" link or mechanism to opt out. In practice, many companies have extended cookie banners or preference centers to cover CCPA opt-outs as well, often phrased as "do not sell or share my data" options. Additionally, CPRA, which amends CCPA, introduces the concept of sensitive personal information and gives an option to limit its use. Non-compliance with CCPA/CPRA can lead to penalties, up to $2,500 per violation or $7,500 for intentional violations enforced by California's regulators. One of the first big enforcement cases was against Sephora in 2022, which was fined $1.2 million for not properly disclosing that it was selling data via third-party trackers and not honoring opt-outs. This shows that even in the US, regulators are paying attention to how companies handle tracking. Other laws. Beyond these, many other regions have their own laws. Canada's PIPEDA, Brazil's LGPD, etc., and multiple US states now have privacy laws. but GDPR and CCPA are often seen as the templates or most influential. For our purposes, they illustrate why consent, or at least clear notice and choice, is mandatory. Key takeaway: GDPR and ePrivacy in the EU mean you generally need an opt-in consent for analytics ads cookies, and CCPA CPRA in California mean you need to offer an opt-out for data sales, which covers targeted advertising. Before we go further into implementation, let's clarify a few key privacy concepts that are frequently mentioned in the context of consent management. Knowing these will help you understand the why behind many requirements and best practices. Consent. In privacy terms, consent means the user has given a freely given, specific, informed, and unambiguous indication of their wishes, signifying agreement to the processing of their personal data. For example, clicking "Accept all cookies" on a banner, assuming the banner was clear about what that means, is a form of consent. Key attributes of valid consent are that it's opt-in, no pre-ticked boxes, the user knows what they're agreeing to, you've explained cookies and purposes, and they can refuse or withdraw consent easily. Under GDPR, consent is just one lawful basis, but for things like marketing cookies, it's typically the appropriate one. A user's consent or denial of consent should strictly guide how you handle their data. You can't override it. That's why Google Consent Mode is implemented, to technically enforce what the user decided in the consent prompt. If consent isn't given, the site must refrain from the corresponding data processing, e.g., no advertising cookies. Legitimate interest. This is another lawful basis under GDPR. It allows data processing without consent if a company's legitimate interest isn't outweighed by the individual's rights and expectations. Some organizations attempted to use legitimate interest to justify analytics or even advertising cookies, reasoning that they have a legit interest in measuring site usage or monetizing through ads. However, EU regulators have generally taken a hard stance. For non-essential cookies or tracking, legitimate interest cannot override the requirement for consent, especially after specific ePrivacy rules. Still, legitimate interest can apply in some cases, like some very limited analytics in certain jurisdictions or for security logs, etc. The main thing to know: you can't simply claim we have a legitimate interest in advertising and drop tracking cookies without consent. That's been deemed non-compliant in most scenarios. Legitimate interest might come into play for some first-party analytics or certain data uses, but you typically need to conduct a balancing test and document why users' privacy isn't harmed. In the context of consent mode, Google isn't relying on legitimate interest. They specifically designed it around consent signals and compliance with explicit consent requirements. For beginners, it's useful to know the term because you might hear it in privacy policy discussions. But when in doubt, especially for anything marketing related, it's safer to assume you need consent rather than trying to use legitimate interest as a loophole. Regulators have made examples of companies that got this wrong. Data minimization. This is one of the core principles of GDPR and good privacy practice in general. It means only collect and use the personal data that is necessary for the purposes you have specified and no more. In other words, don't collect data just in case or keep it forever if you don't need to. How does this relate to consent mode? Google's consent mode, especially in advanced mode, is built with data minimization in mind. When a user doesn't consent, Google still wants to provide analytics ads functionality, but will do so with minimal data. For instance, instead of a unique user ID that tracks the person, Google might use an ephemeral, short-lived identifier just to count an event and then discard it. No cookies means no long-term tracking of that user across sessions. It's collecting the bare minimum needed to later model conversion statistics without personalizing or storing data per user. That's data minimization in action, serving the measurement purpose with the least amount of data necessary. For you as an implementer, data minimization also means configuring tools to not grab more data than needed. For example, if you only need country-level analytics, you might anonymize IP addresses or avoid collecting precise GPS location even if available. With advertising, it might mean if a user opts out of personalized ads, you shouldn't be secretly storing their info elsewhere. You only use what's needed for non-personalized ads or aggregate stats. Neglecting proper consent management isn't just a bad practice, it can land you in serious legal trouble. Let's explore what can happen if you manage user consent improperly or not at all. Regulatory fines and penalties. Data protection authorities have been actively enforcing cookie and consent rules. The fines can be eye-watering. For example, France's CNIL fined Google $150 million and Facebook $60 million in 2022 for making it harder for users to refuse cookies than to accept them. The offense was essentially poor consent UX. Specifically, design choices that nudged users to accept all but hid reject all behind multiple clicks. That violates the requirement for consent to be freely given. In another case, Amazon was fined $35 million by CNIL for placing advertising cookies on users' devices without any consent at all. These cases show that regulators are scrutinizing how websites handle cookies and consent, and they're not shy about issuing multi-million euro fines for big players, and smaller companies aren't exempt either. Under GDPR, as mentioned, the fines can go up to 4% of global annual revenue or $20 million, whichever is higher, truly existential amounts for many businesses. US enforcement, CCPA. While the US historically hasn't been as heavy on cookie consent, CCPA enforcement has begun ramping up. A notable example, Sephora's $1.2 million settlement with the California Attorney General in 2022. Sephora was accused of not informing users that it was effectively selling personal information via third-party trackers and not honoring user opt-out signals, like the global privacy control. This wasn't a cookie banner issue per se, but it underscores that failing to provide proper disclosure and opt-out for data sharing can result in fines. CCPA gives a 30-day cure period for violations, but if you don't fix issues once notified, penalties kick in. As more states enact laws, not having a robust consent opt-out mechanism could lead to multi-state legal risks. Lawsuits and liability. Beyond regulator fines, improper consent practices can open you up to lawsuits. In some jurisdictions, individuals or consumer groups can sue for privacy violations. Even if you can legally defend your position, the cost and publicity of a lawsuit is damaging. For instance, several class action lawsuits in Europe targeted companies using analytics or ad trackers without consent, arguing it violated user privacy. Some cases have leveraged local laws to claim damages for privacy infringements. Business consequences, account suspensions. It's not just governments. Private companies, like Google, enforce policies too. Google has an EU user consent policy which publishers, sites using Google Ads, AdSense, etc. must follow. It basically requires obtaining end-user consent for personalized ads and analytics in the EU. As we noted, by March 2024, Google started mandating Consent Mode V2 for anyone using their ad analytics services in the EU. There were even communications that Google Ads accounts might be suspended for non-compliance or for not implementing Consent Mode by the deadline. Imagine losing your advertising account. That's a huge operational hit. So improper consent management can literally stop your marketing campaigns in their tracks if Google or other platforms cut off service. Reputation and trust damage. Beyond formal penalties, consider the PR fallout. If news breaks that your website is tracking people against their will or was busted by a regulator for privacy violations, users may lose trust. In an era of social media, privacy-conscious users could call out companies publicly. Being branded as a company that doesn't respect privacy can harm your brand value and customer relationships. It's hard to measure, but very real. Trust once lost is hard to regain. Data deletion and operational disruption. Let's say you got user data without proper consent. Under GDPR, those users could request deletion of their data, and regulators might force you to delete data collected unlawfully. That could wipe out chunks of your analytics history or email lists, etc. It's like suddenly flying blind because you didn't set things up right from the start. Additionally, you might be forced to pause certain activities, e.g., halt a retargeting campaign until you fix compliance, resulting in lost revenue. Summary: improper consent management can result in hefty fines, millions of dollars, euros, legal battles, suspension of crucial services like advertising platforms, and damage to your brand's reputation. The cost of doing it wrong far exceeds the cost of doing it right.